Gun banners pushing to squash the Second Amendment protected rights of Americans, secretly placed on government watch lists, are willing to gut the Constitution and abandon due process to curtail private firearm ownership. For the sake of playing to their political base, the gun ban progressives in Congress would erase the constitutional rights of all Americans, shredding not just the Second Amendment to the Bill of Rights, but the Fifth and Sixth Amendments, which the founders saw as the ironclad guarantees of due process under the law. The December 2015 Christmas party slaughter of innocents in San Bernardino, California by masked jihadi couple who were clad in ninja suits and armed with illegally altered firearms, cell phone operated destructive devices, and pipe bombs, the truth has now been erased. Before any facts were even known about the California murders, President Barack Obama blamed the massacre on the insane lack of gun control, suggesting the long radicalized husband and wife murder squad evil would have been prevented by universal background checks. Of course, this begs the question of background checks. Obama is insisting on the importation of tens of thousands of Syrians who, the FBI says, are impossible to vet against terrorism with any sort of background investigation. And the barbarians of ISIS are promising that their killers will be among the refugees. Most of the massive media hype over terrorism and guns is focused on pushing a frightened, gullible, non-gun-owning public into supporting the Feinstein legislation. Senator Dianne Feinstein of California, Democrat, the author of the legislation that would grant the Attorney General sole power to deny Second Amendment rights to any American citizens. The legislation S-551 in the Senate and H.R. 1076 in the House would create a nightmare police state operation in which individuals lose their rights and property simply by being placed on a secret list, declared to be suspected terrorists for secret reasons by secret bureaucracies using secret processes. And there's no way out except through a bizarre star chamber court where evidence is secret and the secret government bureaucrats ultimately prevail. The measure does all this by amending the Gun Control Act of 1968. In essence, it creates a prohibited person category, adding to the list already enumerated in the statute felons, fugitives from justice, etc. Instead, it leaves the definition of who is covered and how they are covered up to the whims of the U.S. Attorney General. In effect, it's like telling the Attorney General that she can make up the details of the law, giving her sole discretion over depriving American citizens of their constitutional rights. This is in addition to the inherent pre-existing problem of the terror watch list and the no-fly list, which together, according to USA Today and other media sources, contain more than 1 million names of individuals in secret databases. Under that system, it is nearly impossible to get off the list. Presumably, the names on those lists would automatically be covered by the Feinstein legislation, which also details how people can be tagged as terrorists for the purpose of denying them their Second Amendment protected rights. It even establishes the mechanism by which they are disallowed from obtaining guns under the National Instant Criminal Background Check, the NICS. On the Attorney General's secret declaration alone, individuals lose their constitutional rights. With the failure to clear a NICS background check, the individual falls into a prohibited person category in which mere possession of a firearm is a felony. Before considering the literal text of the legislation, consider the words of the Fifth and Sixth Amendments to the U.S. Constitution. In part, the Fifth Amendment declares no person shall be deprived of life, liberty, or property without due process of the law. And the Sixth Amendment guarantees in all criminal prosecutions the accused shall enjoy the right to a speedy and public trial by an impartial jury, and be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witness in his favor, and to have the assistance of counsel for his defense. To be sure, the right to be informed of the nature and cause of the accusation to be confronted with the witness against him is nowhere to be found in legislation that Dianne Feinstein is suggesting. In fact, it is hard to imagine that an honest, open-minded person could read the actual language of the legislation and not understand its dangers. For now, the legislation applies to obtaining and possessing firearms. Clearly, it also leaves the door wide open to other constitutionally guaranteed endeavors by Americans. Certainly, it could be applied to a wide range of activities under the First Amendment as well. Read it and fill in the blanks. The measure would grant the U.S. Attorney General total discretion to deny a firearm transfer to an individual secretly declared to be dangerous terrorist. The determination is based on the Attorney General's secret declaration alone. Individuals lose their constitutional rights. Moreover, many states use the NICS system to clear applicants for concealed carry permits. The Feinstein law would thereby turn many permit holders into criminals as well. The same goes for states like Illinois that requires licenses for gun ownership and that use the NICS system for vetting licenses. All of this obviously defies the Fifth Amendment. No person shall be deprived of life, liberty, or property without due process of the law. Yet in reading Feinstein's bill, the worst in terms of individual constitutional rights is yet to come. The measure provides that an individual can apply for relief after finding out he or she is barred as a dangerous terrorist, but those affected are just given 60 days to take it to court. That's a mere 60 days to prove you are not a terrorist. Consider the enormous legal cost of such a defense. Most ordinary people couldn't begin to afford it. Also, in terms of the defense, the law would also throw out federal rules of evidence and shut off any unusual discovery allowed under those rules. Of course, to defend himself, an accused citizen would have to find out the information the federal government has collected and where that information came from. Yet to prevent legitimate demands from accused individuals for justification of being placed on the list, Feinstein has the government covered. Any information which the Attorney General relied on for this determination may be withheld from the applicant if the Attorney General determines that the disclosure of the information would likely compromise national security. Here's an example. They may claim, "This man is a terrorist. He belongs to the NRA." That's it. Perhaps out of 100 pages that they won't let you or your high-priced lawyer see. That will be their claim. And speaking of redacted, we saw how the Obama administration used that tactic during Darrell Iss's congressional hearings on the Fast and Furious. It had everything but page numbers blacked out. How on earth could one fight for restoration of his rights when he can't even obtain evidence against him or even find out the source? Again, recall the wording of the Sixth Amendment. A person has the right to be informed of the nature and cause of the accusation to be confronted with the witness and witnesses against him. Simply put, that would not apply here. And there is even more. In a remarkable break with the constitutional concept of separation of powers, Feinstein mandates what evidence a court can consider and what is off limits. Upon request of the petitioner, or the court's own motivation, the court may review the full, undisclosed documents ex parte. Obviously, this isn't justice. It's the very definition of the leftist demand for social justice. In the world of Feinstein's legislation, you are in fact guilty until proven guilty. At the core of all this is the question of who defines suspected terrorist. Were it up to our current president, every act of radical Islamic jihad would be relabeled workplace violence. Would it be out of the question to think that perhaps one day just being a member of the National Rifle Association would fit the bill of being appropriately suspected and land you on the list? Most recently, the New York Daily News laid out its own definition of NRA as, quote, only nearly state-sponsored terrorist group that is not listed by the U.S. State Department as such. The reason? For unending lobbying that's kept the lid on gun control. Therefore, the NRA should take its rightful place on the State Department list of terrorist organizations because its influence is more of an immediate threat to the lives of our citizens than foreign terrorists. End of quote. NRA members as terrorists. The Brady Center certainly thinks so. Back in 2011, that gun ban organization produced a frothing manifesto titled Guns and Hate, perhaps a better description for their own organization. The NRA should be aware of the ominous connection between its inflammatory rhetoric and violent acts of domestic terrorism, the group wrote. One of the great tragedies of all this fundamental danger to our freedoms is that the people who should be reading and understanding the black letter of this proposed law, the media, are too lazy, too biased, or too wedded to the notion of civil disarmament to report what the legislation actually says. In a New York Times editorial, quote, "Truthfully, no one should be allowed to buy assault rifles or other military-style firearms, and the country would be better off with much stronger gun control laws for other firearms that exist now." This is perhaps the most disconcerting aspect of the whole no-gun list craziness, the ease with which elements of Congress, the media, and groups like the American Civil Liberties Union can slip out of their self-appointed roles of guardians of civil rights and ignore such injustice just because it involves gun ownership and an armed citizenry.